Uh, Thank you, Mr. Pierce. All right, now we'll go ahead and open up the platform for questions. What I'm going to do is I'll take one of these wireless mics, and hopefully you wrote down your questions that you have. And Mr. Pierce and Mr. Stevens, if you could kind of remain up here. And so as the questions come through, what we're going to do is everyone will be limited to one question, very specific to, and not going off on tangents so that we can respect everyone's time. And as everyone does one question each, then we'll, look at the time and we can go for a second round for your second question. But we want to just kind of keep it very specific and straight to the point so that everyone can participate and we can have a dialogue going on. And from there, we'll go ahead and break for lunch. So if you can come forth, Mr. Pierce and Mr. Stevens, and as I go around, and just raise your hand if you have a question, just raise your hand and I will get to you, okay? Testing. All right, so. And for the record, state your name.
Hi, I'm David Watmore. I just have a really specific, brief question. When Mr. Pierce was talking about extended use equals or roughly the public right-of-way, I'm wondering, is that similar to that term of prescriptive easement?
It gets easily confused between the two. So a prescriptive easement is more along the lines of adverse possession, where you are asserting a right to use through open, hostile, kind of adverse use. The difference is, the way they talk about it in the court cases with public dedication is that there's an offer by a landowner and an acceptance by the public. Now, that sounds very formal, but then all the other court cases explain that an offer can be where a landowner just permits the public to use it, and the public assumes and has continued to assume that they had a right of use. So the court has said that if that meets, if there's sufficient time, and that's a case-by-case kind of analysis, if there's been that offer and acceptance, it exists. And the point that the courts are making, and I think this is an important one, is that we're not encouraging adverse possession of land, of trails. What we are protecting are historic uses that clearly were assumed by all the parties, including the private parties, to be public rights. So I hope that helps.
I'm Clarence Kuching to Tom. I want to, in reference to the Kulian Act of 1850, as it is written, showed us in the slide, I would think that the most important part of that is the part that's not written, because it says that, these rights go to those who have been granted fee simple ownership of lands. But it seems to me that it should apply to all people, whether you get fee simple ownership of a parcel or not. And so, and you inferred that what I'm saying is true. And so I think that sometimes we have to read between the lines and even place significance in things that are not written, because they are sort of like understood that they're included. I don't know. Would you comment on that?
Thank you. I appreciate that. And keeping it at a really, because these things can get complicated, but when they stated that this right could exist even when there's been a conveyance of fee simple, in the minds of the folks who were writing that at the time, they were saying, what is the most powerful private ownership you can have? And at that point in time, it's this term that is kind of antiquated now, fee simple. But it means that you believe that you have what's called the whole bundle of sticks. You have all the bundle, the person who's selling it to you or conveying it to you is giving you the entire bundle. But what that is saying is it's saying there's some sticks that are removed from that bundle. You do not have them all, even though you declare yourself to be fee simple owner. That's, I think, the most important point. To the extent there's something even subsuming that, that is a different kind of landowner right, certainly I think there's something to be said for what you're saying there, Mr. Ching. Thank you.
Do you have a phone number or email address where people could contact someone to get further information as different questions come up?
Well, I think this actually goes to the next steps that some of you who are going to be participating tomorrow morning, unfortunately won't be able to. But I think one of the things that has already been talked about yesterday when we were hiking around on the trail, and that's a great place to have ideas bubbling up, was the idea of starting to create either seminars or workshops or even a handbook that talks through how community citizens can understand and know enough to start representing themselves at an early stage in administrative hearings. And I think that's something that we can all play a part in. I certainly can make sure that this PowerPoint is available. Then there are community groups that are already reaching out to me, and I guess the biggest point is that that it's important, I think, at this stage for it to come through a couple of focused channels and for us to have a real direction on what we're doing, because there's a lot of issues out there. So the biggest point is of our program is really that there will be questions, but we need to empower folks to be able to answer a bunch of those that they can and actually start representing themselves at an early stage in the cases. I hope that helps a little bit, but that's certainly, well, it certainly is something that needs to come out of this. Right. Well, I think it needs to start here, and you need to start building that information base right here, because there's a, you know, and I just think that's where it's got to start. It doesn't take that long. I can certainly download some of the stuff, but that's the thing, is for you to start creating an information base and an expertise right here in your own community, and that's very important. And that's really where it needs to start. That's the first place.
Richard Spacer, thank you, Richard and Tom, for being here. This is really great stuff. Taking the idea of fee simple, as you know, one step higher was registering lands in the land court system, which the landowners thought would be even more inviolate from future claims. And at Lepeuli, we have a land court property from 1943. And the attorney at the time made a very, very specific statement and said that prescriptive rights do not occur on lands courted property. And I've heard what you said, that we prefer to use a historic trails approach to getting our trails, but nonetheless, that is an issue that we have at Lepeuli. So was that attorney right or wrong?
Okay, so land court property, as folks may know, is an additional layer that you can do to try to quiet title to your property and have vested all your rights in it. There's two things I would just point out is I don't think that the courts have actually ever recognized a prescriptive right in a trail here in Hawaii. I think that's probably safe, but it does come through in a very similar kind of fashion through the public dedication process I spoke about. But one of the things that's very powerful, just because it's land court, there are a couple of really important decisions out there that say that the courts have said, you showed us your land court title, it doesn't show a road on it, but you cannot take title to that portion where a road is proven to exist. And there's been a couple of cases where that's been the argument that's made by the landowners. We've got land court property, it didn't show up as an encumbrance on title. And what the courts have said is, if the plaintiffs come in and prove that it was on a map and it was a public road, that continues to exist under the Highways Act as well as under the other kinds of laws. So the fact that it's been land courted is not the end of the story.
Thank you.
The question was, is there a statute of limitations? And that's a very different kind of conversation, but let's just say that I think that all of the issues that are ancient trail issues remain, at least at first impression, as ripe for folks to continue to assert. And certainly under the Highways Act it does, because the Highways Act, unless it's been expressly dedicated away, the government, the state of Hawaii in this case, now continues to have a right of ownership in that trail, clearly. So that's an existing and continuing right that can't be knocked out by a statute of limitations claim.
Aloha to both of you. I'm Kipukai Kuali'i, and I had to change my schedule to be here this morning, but I'm so glad I did. And I wish I could be with you in the afternoon, but already I've learned so much, and I'm really motivated and inspired. I wanted to ask about the trees and trails, and if there's, we're all thinking about food, growing our own food, and sustainability. And with the food and trails ideas, are there any low-hanging fruit? I mean, is there specific trails that lead to places where we grew lots of food, whether it's forests in the upper lands or in the lower lands historically, and that we can do again? And I will say that I live on the Hawaiian homestead in Anahola, and we have like 3,000 acres of land that go from the ocean to the way up Mauka. Lands along streams and, so potentially fertile lands. And I'm interested to know about the trails there and about the programs. And have you worked with the state? I think the Department of Hawaiian Homelands and DLNR, I mean, potentially there's low-hanging fruit there, I mean, if you will.
That's a very good question. And right away, the first response to this that occurs to me is that the lama tree, which is a very special tree, sometimes called the e-lama or the Hawaiian persimmon, I'm convinced will soon be found to be one of the new superfoods. That lama fruit is delicious, it's beautiful. The trees have a very spiritual meaning also, healing aspect to them. And so that's just one example. But the program that I mentioned that pays the $11 plus for Hawaiian trees also pays for other kinds of trees. So Polynesian introductions, food trees, it's paid at a lower rate. But you definitely can use that to finance activities. And as I mentioned too, very important is the preparation of the land. So that often involves cutting and chipping of invasive species as just a way to get ready for your planting. So there are some wonderful opportunities for that. And checking into your local NRCS, Natural Resources Conservation Service office here, I'm sure they'll be very eager to sign you up. And it's a wonderful idea. Thank you.
I'm Charles Brown. What is acceptable behavior for stepping out of traffic on a trailer and resting?
Sorry, would you repeat that question, please?
What is acceptable behavior in stepping off out of the traffic on a trail and resting?
Resting. Or are you talking about stepping off the trail and perhaps onto someone's land, private land? That's a question that has never occurred to me. Resting in the trail is always good, and just as the trails transmit energy through our feet, they can transmit it through our whole body if we want to get in contact with that trail. So I would suggest doing that. I don't think you would have any trouble resting beside the trail. So hopefully no one will disturb you while you're doing that.
Hi, I'm Felicia Cowden. I so applaud the success that happened, both with finding the trails and then, Tom, with your success with Haleakala. And my experience in watching public affairs is that pretty soon there's going to be some preemptive laws coming through the Senate and the legislature to stop this. So my concern is are you or anybody being vigilant to watch for that, and how can we all be alerted so that we can be part of the posse to stop the preemption, because that seems to be the pattern here. Success, preemption, success, preemption.
This is a really great question, and this is why I'm fortunate that, first of all, that I've had, 4 or 5 months away from the case. It's actually not quite over. We have some hearings next week, but we're past the really big battle, and it permits me to have some perspective and really be the person I tend to be, which is an optimist. But let me just tell you a couple of things. Is we knew we had a straight good fight in court. We knew the law was on our side, okay? And the landowner knew that as well. So a couple of things that in the midst of us as a small nonprofit having to do all the work that we had to do against a major law firm on Oahu, over 25 attorneys, what we had to do in addition to that was the landowner proposed to the Department of Land and Natural Resources that there be a land swap of the Haleakala Trail. Even before this was proposed, even before we had determined ownership. And the point was to basically, under the statutes, trade it for a Jeep road on the back of the island that certainly some folks at DLNR thought was a good trade because it permitted them to get into some biological areas. But essentially what we were giving up was we were trading away an ancient historic trail with an incredible, amazing history for nothing more than a pasture land Jeep road. And this was being proposed by DLNR without any type of evaluation of the costs or what they're going to get, what the impacts would be. We had to mount a huge challenge in the middle of preparing for trial, and that issue went before DLNR in December, which is not a great time to be rallying the troops. But what I can say is that a lot of folks came to the rescue and testified against that. We presented our case there, and I want to actually show my appreciation for Office of Hawaiian Affairs, who was there to testify against it, as well as Native Hawaii Legal Corporation. We were able to persuade DLNR that they were going to violate numerous laws, including environmental impact statement laws, that would be involved here. But the point is that unfortunately, and I said this to the Open Space Commission, and for those who weren't there, I don't want to try to repeat myself too much, but I want to say something, is that I think the folks inside DLNR are good folks, but they ultimately have to answer to someone higher than them. And that's why I continue to say that this is all about creating the importance at the highest level, whether that be with the governor, the lieutenant governor, and other power brokers in our Hawaii system. And a lot of them are open to listening to you and having that information trickle back down, because if they play the leadership role and they say we cannot stand to have this happen during our administration, DLNR will do the job that they know that they're supposed to do. So I guess what I would say is don't shoot the messenger. The staffers, I've worked with a bunch of them, they're diligent, and in our case, once they were given the green light to do the right thing, after we sued the state, we had to sue the state at the beginning of this case in order to bring them around, and after a year of litigation against the state, we entered into an agreement where the state agreed to work with us on the ownership issue. We still have to resolve the public access issue, but we agreed to go on the ownership issue, and that was a huge win, because the state should be at our side when we're going and protecting trails. And they recognized that there was some risk there, and they were willing to work with us on that. So that was a great thing, and the folks that I worked with DLNR from that point forward, once they had a statement which permitted them to, they were doing their part. So the other thing I just want to mention is that wasn't enough. We were able to stop the DLNR proceeding from occurring, although it was very close to happening, very close. So no land swap happened on the Haleakala Trail at that point in time. I can't say that we're totally out of the woods yet on that. But the other thing that happened was during the 2014 legislative session, there was a proposal that the Highways Act, which you've just learned what an amazing act it is and significant in terms of the time that it came into place and the fact that it embodies so much of Hawaiian history. There was a proposal that the Highways Act be amended. And the amendment was to take it back retroactive to January 1st, 2011, which is about 2 weeks before we filed our lawsuit. Okay, so, you must remain diligent. You cannot just assume that these things are going to be fought in one place. You have to be ready. You have to be agile and be ready to look. You have to have people who are paying attention to what's happening. I will tell you the good news is that, that there was a change made in the law that's favorable to us. I think as a direct result, there was legislators that realized that the land swap idea was really bad, and it's been used in other cases dealing with cultural assets, and they changed it because essentially if you can get it through BLNR, you potentially are going to have a green light before the state legislature because it had to be rejected by a 2/3 majority. But that has shifted with the 2014 legislature, and I think that's very powerful because what it shows is we cannot continue to be reactive. People got that passed because they went out and they explained these issues to their leaders. They said, I want to sit down to you face to face. I'm not here to antagonize you. I want to explain this to you, have you understand it. And we had legislators that went to bat on that issue and switched it to where now you have to have a majority of the legislature before you can have a land swap. And I think that's where the power needs to be. It's more efficient, it's more productive, and it'll decrease the polarization between the two parties and create an opportunity.
Okay, aloha. Evelina Maikako, greetings to everyone here, seen and unseen. I invoke the spirits of our kupuna to also be here to see what we are doing, what we are discussing, and to guide us in our thoughts about this. My name is Puanani Rogers. I was born and raised in the Ahupua'a of Kealia, where I still reside with my family, my children, and my grandchildren. I am Kanaka Maoli, and I am Hawaiian national. And saying that, then, you must know what my mindset is. And that is, I have a problem with Hawaiian laws and Western laws. Just now, speaking about land swaps, I think it is ridiculous that the state can think that they can play around with our laws and swap them or sell them or lease them or whatever when they do not own the lands. Every single piece and rock of the state lands belongs to the people, period. So I would like to see Hawaiian laws precede and override any Western laws because to me, Western laws are not legal. They do not have the power or the authority or the jurisdiction to rule over our lands. So whenever that comes to fruition where people are finally going to admit that, and that includes the County Council of Kauai, the Planning Commission of Kauai, and all agencies that feel like they can rule anything that happens on our aina, as well as our resources. So we have to continue to speak this truth wherever we go, whenever we go to any government agency. Tell them the truth. Make them see the truth. Okay? I would like to see when Hawaiian laws will override state laws, and I think that we're getting there with your situation, bringing up the laws that were before Western occupation. And that is my hope and my prayer. And I thank you very much for bringing this up and for raising my awareness about the situations that are happening with the aina and our culture and our resources. Mahalo.
Hi, my name is Andy Bushnell, and I just wanted to ask Mr. Pierce if we are quite certain that we have evidence that there is, in fact, a trail that goes over private property, but there is nothing left on the land that can be proven to be the trail itself. Is there still a claim for that trail? And if so, how is the exact location of the trail determined?
Well, this gets us into a really important implementing and tools kind of process. And I guess the question I just asked the moderator is, from my personal interest, as well as I know we're really, I think that's an issue that either gets talked about a little bit in the afternoon personally, or at our next workshop, because I'm really concerned about some of the other speakers. But what I'll just say very shortly is there's a lot of work that has to be done. You have to lay the groundwork. That's the kind of thing that we want to start passing through. This is a first step, but it can be done. Just because you don't have it on the ground, but it's on a map, that can make a difference, and that can be a great thing. Or
Well, no, that's
maybe a different answer.
No.
Okay, all right.
No,
Okay.
So
the point I would just make is that you got to look at each one of these differently. You have to do your research, and don't stop just because one thing looks like it's a problem. These, as I mentioned before, the facts are usually a little bit messy, but you got to figure out what you've got and what you don't have, and then you make your evaluation.
Thank you.
Aloha, Jack Smith here. Just a quick comment about trees and trails. Kipukai and the rest. Llama is probably the only indigenous or endemic Hawaiian plant that has edible fruit, and it's not really low-hanging. We have ohelo and blackberry, but so there weren't very many when the Polynesians actually arrived. They brought a few. My question was though, it's obvious that there's a lot of trails that are unidentified, but for the ones that are, is there a list or a map for utilization for when we want to do it in a proper way? And is that map or something we can use if we want to be adversarial and use a trail that may be blocked by landowners or whatever? Is there, I know you don't recommend the procedure, but is there a protocol for using a trail that may have a chain link gate on it? Well, I won't mention that specific one, but.
Well, so Hope and Tim have understood that a lot of these are the questions, and there's a speaker exactly on that point. So stand by.
Well, well, I know, but we need to go by system. So who was that? Oh, did you have your hand up? Okay. Okay. But don't all rush at one time.
Donovan Kabibi, Hawaii Independent Media, grassroots local news network. Couple of significant things that should be pointed out is the fact that when the overthrow happened and the provisional government was created, they adopted kingdom law. And so what we see today is a foundation that is a Hawaiian foundation. And systematically, that foundation has been being eroded by outside influences. And so there's very few host culture representatives that exist within the framework of the government as it exists, which leads to the fact that the Hawaiian heart, the Hawaiian fundamentals are absent because it is not physically possible for you who are not Hawaiian to have a Hawaiian interpretation. You can have an interpretation of a Hawaiian interpretation, but it will not be a Hawaiian interpretation. And so, I feel it's very critical for our legislators to work with the various grassroots organizations that exist who hold the knowledge, ancient knowledge. All of us Kanaka Maoli hold the connections to those ancient wisdoms, and we can all lend insight as to what the Hawaiian heart is and what the Hawaiian mind frame would be in dealing with law. And so I want to continue to mirror and share your voice as far as getting involved, particularly the Kanaka Maoli community. Because if we don't, and we continue to allow non-Kanaka to rebuild on top of our foundation, that is where we will see the death of our culture as we know it, and a new Hawaiian culture will rise from that. So with that being said, I, again, strongly encourage our legislators to keep that in mind and continue to work off of the original foundation, because the wisdom of how our people were cared for is in the Hawaii Revised Statutes, because that is the original law of our place that we live in, Hawaii, the occupied kingdom of Hawaii. And when you guys are out there doing your law, it'll serve you 100% personally to adhere to the foundation instead of disregarding those philosophies like we often see happening. My question is, there's a flagrant disregard for that wisdom and the knowledge that exists there. Many of us, there's several cases here on Kauai, Larson's Beach, Papa'a Bay are two significant examples of how private land ownership have come in, restricted access. The people who are in the community, who have lived in the community and can trace their roots back multiple generations, have actively used many of these trails, can speak to the significance of the trail and also speak to the historical connection of the trails, and yet the burden falls upon us to prove those things when the burden should be on the judiciary and the legislation to uphold the laws that have already been established, that are already created. More so just a statement, sorry.
Okay, thank you for sharing your mana'o. What I do want to advise everyone is that we all have thoughts, comments, and wisdom, but please be very specific to your question. Separate your comment and your mana'o versus your question, because we want to go ahead and hunker down the key questions so that everyone can share the knowledge. And then, of course, any wisdom that you have, feel free to share it during the open panels. This is not closing you off to not sharing it, because we love to hear it, but please share it on the proper platform. And next, thank you.
And let me just respond really quickly on one thing I failed to mention before. First, thank you for that. I appreciate it. And I think it's the voices that have to be heard and recorded, especially when it comes to trails. I tell folks it starts with you recording this data and keeping track of it. It's very important. So I appreciate those words. The other thing I just mentioned that's very interesting about the Kauai Springs Trail, the Kauai Springs case that I mentioned about public trust, is that it says in it that the burden is on the person who's coming for the application. So if you have someone who's applying for a land entitlement on a subdivision or something like that, the argument actually that could be made based upon that case is that the burden is on them to show that the trail does not exist. That's at least one way to interpret that. And I just mentioned that, once again, we need to use all these ideas, so I appreciate that. Thank you.
Aloha, I'm Joanne Yukimura. I'm on the County Council. And my question is for Tom Pierce, but I want to just say to Dr. Stevens, thank you so much for your opening presentation, which was a perfect opening, a weaving of mind and spirit. Thank you. So for Mr. Pierce, my question is twofold. One, the victory which I'm so impressed by that you had in court was at the circuit court level, and do you anticipate an appeal to the Supreme Court, or where would that stand? And my second question is, you said you established the Haleaka Trail as a public trail, but there's still a remaining question of public access, is what I thought I heard. And if there is a distinction, because my concern is also how you will manage that trail.
Okay, so we are at the circuit court level, and that means we're at the trial court level. We have proven our case before a jury. There's more complications to the case. We actually have a hearing next week because the judge bifurcated some of the issues. Some of the issues were heard first and some were set for later. We may have a resolution of the case next week. We'll find out. At some point when the case becomes final, there may be an appeal filed. And we always expect that possibility, especially when you have a contentious issue that's been hotly debated for years and hotly litigated for years. So that certainly is a possibility. And we certainly hope that the Hawaii Supreme Court will continue to recognize the work that was done by the jury at the lower level, which is very, very powerful. And we think that the judge did a great job in terms of fairness for both of the parties in the case. So, so the appeal may happen, we'll find out, and that certainly will get circulated if it happens. And if that happens, it's going to be a couple of years before we have a decision. The other question relates to public access, and you know, access is a much more complicated matter, and I think it's going to be a workshop unto itself. Each trail is unique. The Hawaiians understood certain trails to be unique to. And then it depends upon what happened to them perhaps in their early history. It's something that has to have an incredible involvement of the Hawaiian community in this issue to decide that. That's my personal feeling. DLNR, of course, has a regulatory scheme that's there to protect environmental issues and even cultural issues. And I think, once again, it's still in the process of being rolled out, but I think the Ahamoku project has a lot of possibilities in terms of really making sure that there is a strong voice at an early stage for Hawaiian issues. So when it comes to public access, the thing that's quite unique about Haleakala Trail is that it was improved by the territory of Hawaii, and it actually has a slightly different path than at least portions of it have a slightly different path from the old Hawaiian Trail. We're in the process of working through what is the appropriate public access with that, and I think it's important for all the parties involved that we do it right, and we're talking to the state. We're hoping that we reach a resolution with the state. That was part of our agreement in dropping our lawsuit. We have the right to re-bring our lawsuit if we don't get what we think is appropriate. But once again, Haleakala Trail is a bit unique in that it was really westernized in a very significant manner with a different rerouting and those kinds of things, and was used until 1935 as the only way to get to the top of the trail. It clearly was the way to get to the top. So it makes it quite unique in that respect. But that's something we're working out, and we're certainly taking into account, and when I say we, the clients that I represent, which includes Public Access Trails Hawaii, we recognize that this is the beginning of what is the next step in any one of these. Ownership is just the first step, and in a lot of ways, like I said, it can be the simpler one in some respects. And then we have to deal with user rights and trail access and adjacent property owners, those kinds of things. But we think that there is a way to do it. We think that it's just an issue that needs to get vetted with the public, and we create a system, and we continue to tweak it and massage it and get it right. I don't know, do you want to add anything on that one? Okay.
My name is Ted Blake. My interest was piqued when you spoke about the 1850 Kuleana rights, and you mentioned that rights on spring water, running water, etc. And this will all tie in. I mean, how do you prevail on a large former plantation owner that diverted water forever for cane, diverts it today, and sells it to people down the stream, and yet doesn't let the flow go, and he prohibits local ia from being productive and Kuleanas from having water for the low E? Is it as cut and dried as is the law as cut and dried the verdict? Is it cut and dried as this, or you got extenuating circumstances?
Well, when it comes to water rights, I'd rather defer to some other people in the room that might be willing to volunteer. I don't know. Or we should save it maybe for this afternoon. The one thing I would just point out is that there's, and from our perspective, when we evaluate the Kuleana Act, there's two parts to it. There's the first part that deals with Kuleana lands, and there's the second part that is that part that I quoted from, which is much more a broader, common public trust kind of thing, and it includes water, streams, running water, streams, and it includes roads. And to us, that was embodying a concept that was at commons going all the way back to the splintered paddle. It's the idea that that's something that's there for everyone and is maybe separate and distinct from a Kuleana right, And what we know is that with respect to the waters and streams, the Supreme Court has already ruled on that portion of that little phrase that that concept is a public trust concept. So if it applies to water, it certainly applies to trails. I know your focus is on the water, and maybe we can get Alan in the afternoon on one of our Alan Murakami to talk a little bit more about that, because NHLC is really taking the lead on the water rights cases.
Hi, my name is Eric Burton. I got a question for you about the splintered paddle, which is that Mama Lahoa? Sorry, it's been a while since I read that one, but so basically he's a kid and gets hit over the head in the canoe by some of the chief's men and he feels it's unjust, and later on, now that he's king, he puts in this law that says everybody has the right to walk along the trails, and I believe the wording in there that says and to lie on the trail, is that? So how does that deal with people, because some of the trails are more than a day's journey, and so any idea how that relates today to people who may not have a home and who may be journeying on those trails? We have a lot of folks that are hurting and struggling, and I'm just kind of curious about how that may relate to some of those. In other words, how do these rights, other than just walking on the trail, are any of those preserved?
I'm probably not going to answer your question, and I'm sorry, but first I would just say that I would defer to a real Hawaiian linguist to actually do the interpretation of that, and I've seen it interpreted in a few different ways, and I think we can all take some things from it. As I said before, what I think is powerful about it is, and what I understand about the story is that it was a reflection of the king, in that case, which has a bit of a myth around it, in terms of the story. There's a story behind it, and what I took from the story, and I think we can all take something valuable from it, but from what I took was it was a king recognizing that even though in a different situation, the king has the right to, basically kill someone, because that's the way I've read the story, was that this person was brought to him later on, because the story that I read, and once again this may be different depending upon the interpretations, but we have commoners who were helping someone to hide a child, and the king's foot stuck. The commoner, in this case, did not kill the king, and that was the possibility. So I think it created, this moment in time, created a level playing field and a recognition that on some level we're always equals. And that's certainly with respect to the road, what I see is that that's a reflection that this happened in a common place, and we all have certain rights that are fundamental across the board. There's no one has a stronger point in that walk than anyone else. That's a general concept that I think is just something that's kind of nice as a starting point. And I spoke more than I actually meant to on that, because I really am treading on an area that I would prefer to have some other people speak on if it's important. It certainly is not a law that's been litigated a lot. I can't tell you that from a legal perspective, but I think it's something that needs to be looked at in terms of understanding all the Hawaiian concepts that are embodied in the law today.
Thank you. We're going to end with just this last gentleman's question, but before we end, we're going to be introducing one of our speakers, but she's not going to be able to speak because she needs to leave to the airport. And of course, after this question, we were supposed to break for lunch, but we're going to try to, we will squeeze Alan Murakami from the Native Hawaiian Legal Corporation, because a lot of your questions that you've asked can also relate to him as well. So here's your question.
Terrence Reynolds, on this lie in the road, I was struck by that phrase too. I'm wondering, you're talking mostly about top down, get to the leaders. What if some of these things come to between public and public access and private claims? Would the lie in the road provision do anything for an occupied trail move on a particular issue? If you have a
I guess I don't have an easy answer on that, but what I will say is that, I think this issue could come up again. I think Dennis Hart is going to be one of the speakers from the Big Island, and he will probably have some helpful things to talk about with that one.
Thank you. All right. I'll go ahead and now introduce Naone. Yes.
Aloha. I apologize that I won't be able to give a presentation today. I went to the Big Island for a workshop and came away with a virus, so I'm not feeling 100%, but I'm happy to be here, and I hope it doesn't mean I have to give back the trail mix. because I'm pretty excited about that. I'm Mary Jane Naone, and I'm the new lead Kauai archaeologist with the State Historic Preservation Division. My husband and I moved over from Molokai about 3 months ago, so I'm brand new. I have a lot to learn about the trails in Kauai, and I'm excited. I wanted to talk a little bit about what I perceive as the State Historic Preservation Division's role. And I'm sure some of you will have some information for me too that have a longer history with the Alahele program. What I understand our role to be, well, first I'm sure that you're probably aware that SHPD sees the county permits that come through for pretty much, there's several different types of permits that we review. Any land disturbance, subdivision, variance permits, zoning permits. And so our first role there is to look at the permits and see what kind of historic properties are already on the property and what might be affected by the activity. And so one way that we serve to protect historic properties and trails is to see what's already there and to make recommendations to the landowner about what they can do to preserve those properties. Another way that we protect the trails is in requiring archaeological inventory surveys for lands that have not already been inventoried for historic properties. And these would include requiring the landowner to search for trails on their property and to identify any trails that might be existing there. And this is a great opportunity for me to rely on people in this room to also help identify some of those resources. Another way that we serve the community in protecting trails is working with the Na'alahele program in the management of the historic trails. So my understanding is that we also help in identifying some of the trails that the program is identifying to include in the program, but also assisting in developing the preservation program for the trails and the properties along the trail once those trails have been identified. Because of course, once the trails are opened up for public access, there's a lot of cultural and archaeological resources along the trail. Another way that we assist in preserving the trails is upholding the regulations of 6E, which has to do with any type of damage or destruction of historic properties. And so whenever we get reports, I mean, I'm the only archaeologist on this island working for the state right now, so it's a real cooperative effort, but when we get reports of any type of violations on historic properties, we go out and do a site visit and see what has been done there. So that's another way that we assist in preserving and protecting trails. And then a final way, and I'm sure there's many other ways that we can contribute to this effort, is through public education and outreach. You know, as many of you know, SHPD has had a lot of empty positions for a long time, and so a lot of our work has been focused on review and compliance. But there's actually a lot of other program areas that we address, including things like this, which are much more fun. Public education and outreach, working with the community, and forming partnerships so that we can better protect the resources. So I just wanted to introduce myself, and I came from the National Park Service, so I worked down in Kalaupapa for 3 years. So the Kalaupapa Trail is very dear to my heart because it was our commute to get groceries or even to get to work for several months. So, and I love running trails. So I have a special affinity for trails. I'm really, and thank Dr. Stevens for his presentation because I think he perfectly synthesized the way that I feel about trails. And I'm really excited to be here. And my contact information is available on our website. Just thank you all for having me. And if you have any questions, if there's any way that I can assist you, I'm here to serve the community of Kauai. So, mahalo.
Thank you.